This is an appeal in the matter of Hilltop Experiences and Norfolk County Council.
Morning, Mr.
I appear in this matter with Miss David for the Appellant Hilltop. My learned friends, Mrs. Townsend KC and Mr. Lewin, appear for the County Council. The court should have a core and supplementary bundle and an authorities bundle.
Yes.
And there was a notator's Google which we sent up. As that, I think hard copies have been put up.
Yeah.
The court. So I'll go to that in a moment.
Yeah, you can take it that we've been able to read quite extensively into it, so you can take things relatively quickly. Can I just ask about the division of time between you?
I would aim to be fairly quick. Obviously, depends on the court's questions, really. I appreciate, but to be finished well before lunchtime. It seems possible that the argument could finish before lunchtime overall, but we'll just have to see how we go.
Right.
But there's ample time to deal with that. My lords, because there is really, it seems to us a very short issue. The question is whether the acknowledged error in thinking that all the potential alternative sites were within the national landscape was sufficiently serious to render the decision unlawful. And I can put my case in a nutshell. It's accepted that the advice to the committee that all the sites potential alternatives being looked at were inside the national landscape was wrong, because East Beckham was outside it. The advice to the committee was that the site selection exercise was not done very well. We couldn't rule out the possibility of sites which are being outside the national landscape, but there was a high probability that any alternative site would be within the national landscape. The learned judge's approach to this issue was to say, well, the committee knew that the site selection exercise wasn't very good and that there could be something else outside. So the fact that there had been a site suggested outside wasn't material to the decision. It wasn't an error that goes to the lawfulness of the decision. And my lords, the response, of course, to that is that there is a great deal of difference between the committee being told, well, if there was a proper exercise done, it might throw up something, but it's highly probable it won't, in terms of anything better, to being told that actually, back in 2019, there was a site outside the national landscape and not too far away at all, which would therefore, at the very least, have merited further investigation.
So you phrased the question as the acknowledged error in thinking that all potential sites were within the national landscape.
Yes, my lord.
To what extent do you have to show that this was a potential site, in the sense that it had any realistic prospect of getting to fruition?
My lord, first in terms of what I need to show is, in this case, I don't have to show anything on the potentiality. I will go on to show potentiality just to cover the point, but I don't need to for this reason, which is that the error is thinking that this simply wasn't this site outside the national landscape. The mistake in thinking that...
Well, there may be many sites outside the national landscape. I mean, if it's going to be material, then it has to have some quality or some qualities to bring it into account as an alternative. Because break back to the start of it. The start of it is that the alternative sites in this case, I don't think it's disputed are a material consideration because the policy makes them a material
My lord,
consideration.
that's right, yeah.
So we're not in the world of worrying about Trespass Forte and Edwards and all
Yeah,
those cases that are worrying about whether or not alternative sites should be a material consideration. So then the question arises: so what is it necessary to be confident of for such a site to become a material consideration, so that the committee were not misled when they were told, well, actually, there may be sites outside the national landscape, but we haven't found any.
Yes, and my lord, firstly, I deal with that two ways. One is that the threshold actually is very low because there's no dismissal of this site by the local planning authority. They simply don't fail to appreciate that it exists. So it's not as if there's an evaluation of it by the authority. And the question is, how far can the court go into it? But in terms of whether this, so that, my lord, the legal error is getting that wrong. In terms of the significance of it, this is a site which is just outside the national landscape. It's about 600 metres away. It's got access from the same road, the A408. So it's 418, the Holt Road. So it's just a little bit further down the road. In terms of serving the Sheringham-Cromer catchment, Sheringham-Cromer Holt is where the catchment's referred to. Serving that, it is on its face not much different. There is no dismissal of it on questions of planning merits or location in terms of the process leading up to the decision, even by the county as applicant. There's the planning merit. I'll come to availability in a moment to answer my lord's question fully. In terms of planning merits, the only critique of that is by Mr. Jager in his second witness statement, responding to the point having come up. Now, of course, from the perspective of the court dealing with that, it is not for the court to get into planning merits and a debate on those issues, but as far as the point goes, the situation is, my lord's, quite an obvious one, that this alternative site is outside the national landscape compared to the site which is inside the national landscape. It is a quarry working compared to a greenfield agricultural site. Undoubtedly, in terms of citing a permanent household waste recycling site at that location, that will involve some development there going longer than the lifetime of the quarry, and it will involve a change to the restoration scheme for the quarry. It wouldn't normally assume involves sterilisation of minerals because the quarry is being worked out.
I mean, there's a whole welter of things about which we know nothing.
Indeed, my lord.
How would the site be accessed? The access requirements for the quarry may be very, very different to the access requirements for a waste recycling centre. I have no idea. We have no information on any of that. So the planning merits, you can make the points that you make, but I mean, we're not in a position to determine.
Well, and my lord, the reason I deal with it that way is it's the county council response to try and raise the planning merits. The problem is, which is the reason why I go back to the original error. The error is that, which is acknowledged, is that the county council, as planning authority, thought that all the potential alternatives, particularly the alternatives looked at by the county's waste authority, were inside the national landscape. And they failed to appreciate that this site, which was referred to in 2019, was outside the national landscape. There is a pickup in an email that does have access from the A418. But the question for the court is, of course, simply whether this is a sufficiently serious error to bring down the advice which was given to the committee. Of course, that the court isn't here to judge on the planning merits, and there's no assessment of the planning merits of this site because the planning authority completely missed the site by the error which they've made. But what the court, we're into the question of both the seriousness of error and the sense of the consequences in terms of remedy of the error. But what we have here is a site which, on its face, is a potential alternative. It's not an error which can be sort of ruled out as being immaterial. It's not an error where there is a sort of a long stop point, something which, even though the error was made, we know it doesn't, it wouldn't have mattered. And in terms of availability, what the planning authority were told about the owner not having engaged is a comment which, on its face, was incorrect. There was engagement, and if the suggestion is would then be made, well, actually there wasn't sufficient engagement to take it forward, and so on, then that's a matter which the planning authority needed to be cognizant of and to have engaged with, and simply became because they missed the site, essentially. They simply don't do any of that. So, my lord, those sort of issues that follow on are issues which the planning authority did not engage with because of their original error.
The most of the information that we had are the email exchanges which had taken place, and what is set out in the witness statement. There's no further material provided in support of the, as you describe it, the seriousness of the error in the committee report. That was the material that was before the court below.
Yes, but it was before the court below in terms of availability of the emails and what's said in the witness statements.
Yeah. On
those, in terms of the potential for this as a possible alternative, the points which are in the material below is that, and before this court, first of all, this site is not, the East Beckham site is not in the natural landscape, whereas the site under challenge is in the natural landscape, and the relative physical proximity and there being access at the moment off the A418, so the same road that's being used in the access here. It's not one of those situations where it suggests that the court could look at it and say, well, this is one we can rule out that it wouldn't have fitted the bill to serve the Sheringham catchment, because it's very close to the site which was selected. Bearing in mind, of course, that both sites are both the current site, the appeal site, the current site, the challenge site, and this site, of course, are outside the urban area, and people going, and this is discussed in the material, people going to and from a household waste recycling site will almost invariably be going by car, because they are bringing items which are just sort of, whatever reason, they can't put in their normal street side waste collection. So it is a place somebody's going to drive to.
So there are there really two points of error that you say? The first is the error about the site owner not engaging, and second, the point about the location outside the national landscape. I ask a question, let me just explain.
Yes, in my book, yeah.
The reason I ask it that way is that it could only be of any relevance at all if it was, as you put it, a potential alternative site. And if it was ruled out because the owner hadn't engaged, then it wouldn't be a potential site, would it? A potential alternative site. So do you need to show that there were both errors?
My lord, I don't need to show that there are both errors, but I will do. Put it that way. And it is important, as just in the analysis, to reverse the errors, because of course what we're concerned with is the review of the planning authority's decision. The planning authority make the error of saying that the alternative sites are within the national landscape in terms of those raised, including all three sites raised in 2019. And the court has those references. I'm sure the court has picked those up. First of all, page B180, paragraph 3.21, which refers to the three potential options, and then says all seemingly in the national landscape. The report then goes on at B184, paragraph 3.36, to refer to the three additional sites, all within the national landscape.
Sorry, which page?
Page B184, my lord.
Thank you.
Paragraph 3.36.
Yeah.
So that's where it said in the third and fourth line of that part. So that's the point that's made there about those three sites, and it's put in the context of considering the site selection process has not been, which was carried out by the Council's Waste Authority, has not been carried out as good a way as put it neatly, as well as the planning authority wanted. The planning authority wanted more material.
That's the point that they've made at B180, isn't it? 3.22.
Yes, my lord. So, and the conclusion which the planning authority draw from the site search material is that they can't say that if it was done, the search was done properly, wouldn't find a potentially suitable site was outside the national landscape. And my lord,
That's 322.
Three-
CPA on balance cannot categorically say that no land was available outside the national landscape or on land that would meet policy requirements at the time of the assessments that would cause less harm than the site considered under this application to meet the requirements. And then it sets out the policies.
yes, but what they sort of quantify that to the extent they do in the conclusion section, which is section 4 at page B196. In paragraph I would take up two references on that page, my lords. First, at the top of the page is upon paragraph 4.2, where they say that some weight should be given in the planning balance to the location of facilities between Cromer, Holt and Sheringham having to be situated within the national landscape in order to be suitably located, given the sites available at the time. That we're considering. And then in 4.3, at the end of that paragraph, they say that the CPA, so the County Planning Authority, also see the location as a geographical assessment to meet catchment needs, given its public facility and due to the extent of land the AONB covers. A suitable site would have a high probability of needing to be located in the sensitive landscape.
But before we get there, at an earlier part of that paragraph, they go back to the site assessment, don't they? Back to the alternative site assessment, and they say the CPA would have expected a more recent assessment to have been submitted in order to fully comply with policy, so we can be satisfied no land was available on sites outside national landscape or on land meeting policy CS6. However, the CPA did have sufficient public interest in providing the improved facility when considered in relation to the highways improvement work, landscape mitigation and location of the existing facility, and so on.
So, my lord, there's there's the interest in bringing forward a new site, undoubtedly. The question is whether they've looked at the alternatives to do so. In terms of the first part of that extract, my lord, read about satisfied no land was available on sites outside of the national landscape. The planning authorities' point in relation to that wasn't to investigate the availability of a potential site which is outside the national landscape, but not to think that there were any sites being referred to which were outside the national landscape. I am going to, my lord, come on to look at availability in due course, but stepping through the process, what I'll do is, well, what's the error of the planning authority? How far does that analysis go? That analysis goes no further. The error is location. That analysis goes no further than to say these sites we talk about all in the national landscape. The approach of the learned judge, of course, was dealing with this point having come up after the substantive hearing before her, was to say that the committee were being advised, well, that it's possible that there could be something outside the national landscape. The exercise wasn't done very well. The committee had to make a choice as to whether or not to say, well, actually, we don't think that the site selection process is sufficient and needs to be done further. The most obvious way of dealing with that would have actually been for the committee to have deferred the application, making clear that they wanted a better site selection process. A choice from whether to do that or whether or not to simply take it on the basis of what they have. The advice which the committee had was that, well, there could be something else found elsewhere if the exercise was done properly. But the way that was put is in terms of, as the court has seen, we can't categorically rule out there being anywhere else. The high probability, bottom 4.3, the high probability is that what you would come up with is a site within the national landscape. What the committee were not told, because of the error, was that this site search that had been carried out by the applicant had thrown up a site which was outside the national landscape, and as it happens, not too far away either. So the advice to the committee, the way in which the committee would have evaluated it, could have evaluated it, is going to be quite different from being told, well, yes, you could, essentially, you could say, we should say that there should be a better site selection exercise done, but without any suggestion that was likely to throw up a better site. From the error, effects of the error, was the committee being told, well, the error had been made, the committee were being told, well, actually, there has been another site thrown up, which is not too far away. And that changes the matters in front of the committee. What we very received see why a committee would think, well, look, yes, we could do more work. We were told it's not likely to lead to a different outcome. What's the point of delay that? Make a decision on what we've got. This has been going on for quite a while. No great point sending it back to the situation which on the facts had ascertained that there was a potential site outside the national landscape which had been identified, and the site selection process then is recognised as being inadequate, and they don't then the planning or the council's planning authority simply never actually got onto the question of, well, is the East Beckham quarry site one which is available and potentially suitable and preferable? It simply never actually got onto that question.
Can I just explore the relationship between the two errors that Lord Justice Miles identified earlier? As I understand it, the planning authority wasn't told that in relation to the quarry site, the owner hasn't engaged. That's in the earlier report, but was that before the planning authority?
The plan. It wasn't in the committee report. Yeah. I think so. It wasn't part of the reasoning presented to the committee. The officers would have received the updated planning statement, which has got that material in. It would have been online.
It's available.
It would have been available. The committee, if they wanted to read that, could have chosen to read that. Now, in terms of, I appreciate, in terms of understanding why the committee reaches as a decision it does, unless the committee has adopted particular reasons, the general assumption, it's in the Mansell case amongst others, general assumption is that they are following the reasoning in the committee report if they've agreed with the recommendation.
Yeah. So if it was in fact the case that the owner, because this other site is in private ownership,
yes,
and if it's true that the owner had not engaged, then this wouldn't have been a potential site, would it?
If there's no, if there would be no potential basis for it coming forward, then see, in this situation, the way of analysing it would be to say, well, yes, because it's not part of the planning authority's reasoning, a mistake was made, but it's a mistake which would have had no consequences, because if this alternative site had been looked at, the conclusion would have been reached that it would never have come forward.
Yeah, so it's not.
So it wasn't an actual alternative.
So put another way, the report is not misleading, materially misleading, if it was the case that, that this alternative site wasn't available because the owner hadn't engaged. Excuse me.
My lord, it's just in that case that probably the correct legal analysis is that the report is it's not going to change where result we get to in a particular situation, but probably the correct legal analysis is that the report is materially misleading because it's a site that was raised, but that on analysis it couldn't have led to a different decision. So it's probably, strictly speaking, a section 31 point. There is, my lord would appreciate, a bit of an overlap between is this a serious error and which renders it unlawful, and is it an error which,
well, to be misleading,
that
Mansell talked about when it talks about this being misleading, talks about the it being material. In other words,
yeah.
It was something that was of some significance to the decision-making process.
Essentially, my lord, that suggests actually the issue which arises in this case. There is an error. The question in reality is the materiality of it. And
so it does bring in. You need to address the second mistake,
which is the engagement point, my lord. Absolutely.
Yes.
And in that situation, what the planning authority were told, and for the court's note, it's in the court on short have seen it, but it's in the planning supporting statement. B 95 to 96, where they have a timeline, paragraph 4.6, and a timeline in going over B96, item 7 on the timeline. Just about 3 options were explored, and it's option 1, which is the quarry, and what's said to the planning authority is, however, the landowner did not engage. Now, my lords, that statement, however, the landowner did not engage, is one which is factually incorrect in what we know. At the very least, to be as, if we I didn't invite the court to be this generous, but the court was being generous to the Waste Authority's applicant here. If the assertion the landowner did not engage meant the landowner didn't pursue some degree of engagement, or discussions got nowhere, in essence, if that was how it was to be read, that's a matter which would have needed a consideration by the planning authority on an informed basis. I suggest the proper way of looking at it is that the suggestion that the landowner did not engage is incorrect as a statement. And my lord, certainly incorrect as a statement put in the way it was put. And can I take the court to the correspondence which we now have, and should bear in mind in looking at this, of course, that This is not correspondence which was before the committee. It's not correspondence which the planning authority had or including its planning officers had at the time of making the decision whether or not to grant planning permission. So it's correspondence that's not been evaluated by the planning authority. But let's turn that up. So if we can go please in bundle B to page B64. And that's a letter email from Mr. Robert Batt, whose site it is, to David Russell of NPS, which are Norfolk Property Services, who were consultants who were instructed by the county's waste authority to look for alternatives. Refers to the letter, and he says, which we don't have a copy of, unfortunately. He says there is a possibility of relocating the centre within the Ocean Gravel site. That's East Beckham. Use on the same time frame involved. So we consider the phasing of excavation, perhaps arrange a date, initial telephone conversation. Then at B65, this is internal correspondence between MPS and the Waste Authority. David Russell is, bottom of the page, is back, 29th of July. He says he will follow it up with Robert Batt. Describes it as a reasonably positive response, particularly given the existing highways access serving the quarries, to pick up my lord's points about not knowing about the suitability of highway access. Then Nicola Young, the waste infrastructure manager, is sort of responsive, let's say, relatively positively, and there seem to be a number of potential matters which they're discussing. So that there's then starting at B67. Reference to a couple of chasing sort of emails from Mr. Russell, 14th of August, 3rd of September, and 4th of September, trying to fix up a date. B69, another email from Mr. Russell to Mr. Batt at the top of the page, the earlier ones we've already seen. B71, email from Mr. Russell to Miss Young on the 8th of October. Finally able to speak to Robert Batt as this summer holiday period now seems to have ended. Discussion about trying to come up with dates. B73. Mr. Russell writes to Mr. Batt on the 9th of October, suggesting a number of dates in October and the start of November. And then we have an internal email on the 18th of October 2019. Mr. Russell saying he's not had a response and he had phoned Mr. Batt's office. and then the remaining 2019 email is at B74. So that's Miss Young to Mr. Russell, we could have a discussion with Mr. Denny, who is behind the site that's actually been brought forward in the end. So that's all the 2019 correspondence.
And the page 96 of the bundle, which you showed us first of all, is the document which refers to landowner did not engage. That's all referable to the period summer autumn 2019.
It is in terms of that correspondence.
Would you say it's inaccurate to describe what happened over that email?
Yes, my lord.
Not engaging.
Yes, my lord, because the landowner did engage. The landowner, having received a letter in July, approached saying it is a possibility. There's then, we know there's a conversation on or shortly before the 8th of October. We're also told that Mr. Batt tried to phone Mr. Russell without success, and we find that in Mr. Reed's third witness statement at page B36. Paragraph 8. This is what Mr. Reed in March last year records Mr. Batt having said to him. It's about saying that the council had stopped responding, and the second half of that paragraph, Mr. Batt confirmed he also tried calling a number more times, but no site visit ended up being arranged. So there's, from what we can tell of the evidence, there are sort of attempts by both Mr. Batt and the county council to progress discussions, but there's an element of people not managing to get hold of each other. We don't have an explanation as to why those communications didn't go any further. We do know that by the time this issue comes up, the participants on the council side have moved on, in that Miss Young leaves the county council in 2023, and the reference for that is Mr. Jager's second witness statement at B45, paragraph 23.
Sorry, could I have that reference again?
Page B45, my lord. Yeah, paragraph 23. Tells us that Miss Young left the council, the county in 2023. Paragraph 22. I'm working my way up the page at this point. Paragraph 22. Mr. Russell retires from MPS. Seems to be, given some of the correspondence, seems to be January 2024. So he's no longer around. The paragraph 21 is Mr. Jager saying the interest of party I, the county, as applicant, says that due to no response to the MPS email of the 9th October 2019, it was considered that this option could not proceed. Now, my lords, that's has to be said, a very unsatisfactory statement to go into that and say we don't know who made it within an interested party. We don't know whether the maker of that statement is basing it on their own involvement in 2019, and so their own knowledge of a decision, or they're basing it on some documentary material which they have available. No further documentary material has been produced. We don't know if it's simply an assumption or an understanding from somebody who's come to that matter much later. So we don't have an explanation as to why things seem not to have proceeded, and of course it takes, in a sense, to progress anything. But what the documents don't show is that a failure to progress was down solely or mainly to Mr. Batt not wanting his site to be available. We just don't have information as to what happened.
Is there an email of the 9th of October?
Sorry?
Is there an email of the 9th of October?
The email of the 9th of October we've just looked at. So if my lord goes to
Is it page 75?
yes, page 75, and we looked at also actually page 73.
Yeah.
So that email at the bottom 73 is one that's one that's being referred to.
And it is, I think thereafter there is, the email chain doesn't reveal any further response from Mr. Batt, but the witness statement you showed us earlier suggests that there were multiple times he tried to contact the council.
Yes, and the time that so we have that information. The timings within that as to when those calls were and so on, we don't have that further information. What then ultimately happens in terms of any dealings between the county and Mr. Batt, the only other document we have is his email in 2021, which we find at B76. And that's an email of the 5th of May from Mr. Batt to Mr. Russell. It's the uncopied in on it, which in terms of the chain is following on from the 9th of October email. Saying we were going to meet, the whole plan seems to have got lost over the last 18 months. Perhaps in the case of something that the county would still like to consider. And my lord says no record or suggestion of there being any reply to that email. And nor is there any suggestion material coming into the planning authority that the quarry owner had contacted the county in 2021 essentially asking, is this something which is my site coming forward for your purposes something you still want to consider? And in terms of the time scale, just to put us in the chronology in mind, it's in January 2022 that the council's cabinet agrees to enter into the lease for the application site. We find that for the note at B94, paragraph 4.5, which is part of the January 2024 updated planning statement.
What page again?
Page 90, B94, my lord. And then the application itself, the planning application, is made in 2023 in February.
Was the lease subject to planning permission, obtaining planning permission, or is it an absolute?
I don't know, my lord. We've not seen the lease. Well, I said I've not seen it. It wouldn't be unusual, my lord would appreciate, for an agreement for lease to be conditional upon planning permission, because the county wouldn't want the site if it didn't.
Well, that's why I asked the question.
So that may very, very likely the case, but my lord, I simply don't know. So, in terms of the statement made in the comment in the planning statement, the landowner did not engage. My lords, that's a statement which, on the evidence which is available, is incorrect. The site wasn't pursued. Reasons which we don't know, all we have is the evidence of attempts of communications in both directions within that. But as it was being put to the planning authority, the landowner did not engage. That statement is one, my lords, which was incorrect, because there was engagement. The reader of that statement, the planning authority, was just basically the applicant saying, well, we wrote to the owner of the quarry, didn't get anything back, didn't get a response. And my lords, that's not the position. The position is there was response. These didn't proceed very far, undoubtedly, but there was a response. That response was initially positive. For some reason, discussions seem not to have continued. The landowner then comes back in 2021. The council don't respond.
It doesn't seem as though the discussions proceeded at all, in truth. I mean, there was just an exchange of emails about setting up a meeting, and that all petered out, and Mr. Batt wrote back saying, are you still interested, and got no reply. That's as far as it went.
Yeah, I would add to that summary, my lord, that Mr. Batt's response was initially positive. Look, there is a possibility of this, and
Well, he took the trouble to write back after 18 months. But
well, and
in the set, when you said it didn't proceed very far, it just struck me that actually, in truth, it didn't get anywhere. But we've got the emails, and they speak for themselves, don't they?
We've got the emails. Mr. Batt's initial response, taking back to July 2019, is, look, there is a possibility, and perhaps we should talk about it. What we then have on the record are some conversation on the 8th of October, but not much said recorded there. And we have attempts on the evidence we have in 2019 of both sides trying to fix up a substantive discussion. We don't have evidence that there was ever a substantive discussion that took place. And as my lord said, when Mr. Batt does get back and does follow it up in 2021 and gets absolutely no reply at all, is again on the evidence which we have.
And that email isn't referred to in the table that you took us to on page 96.
No, my lord, not at all. No. So the planning authority have no idea that that there was a contact in 2021 saying essentially, are you still interested in talking to me about my site? I mean, if they'd appreciated what the site was. So, my lords, in terms of whether the error about where the site was something that mattered, and also about whether the information the planning authority had was accurate about availability, about non-engagement. The position is it is an error that mattered. This isn't a site which could be ruled out on the evidence as not being available. What the evidence points to is...
Well, it depends what you mean by available, doesn't it?
Well,
it's there.
Yeah,
I mean, availability
Yeah.
can cover a multitude of sins. The site can be available if it's just physically there. At the other end of the spectrum, it can be available. The test of availability can be, it's there, it's got planning permission, it's got a willing owner, we've done a deal. So
Yeah.
you use the word
Yeah.
available, but that's a portmanteau term that can cover a multitude of situations, can't it?
Well, it can, my lord, which is why, of course, we're dealing with a situation where, first of all, it matters that the applicant is dismissing the site, the landowner did not engage on a that rather sort of absolute and, let's say, not, at the very least, not full, not this anyway, inaccurate basis, where the question on looking at availability on alternative sites basis, if any applicant is being asked, well, is there somewhere else that this might be, how do you dismiss that? Then you would have and it's a regular issue when we're dealing with alternatives, as people appreciate. In that situation, not really looking at availability in the context of there being another site that's got planning permission and everything in place, because it's a search for a site where you could get the consent, and it won't be a site where there is a deal, because the applicant is coming forward saying, well, this is the site we're bringing forward for permission. It's in one way or another, this is a site we've got control over.
Well, one way of looking at it might be through the prism of how the framework deals with housing land supply. Paragraph 72 of the framework requires that sites should be taken into account dependent upon their availability, that is to say, that they are in the market, can be accessed, suitability, and likely economic viability. Those are three tests that would go to the weight, wouldn't they, of whether or not something which was an alternative site should be afforded some weight and consideration.
Just caution against applying what is a different set of tests for different purposes. The purpose, of course, Lord appreciated, of those kinds of availability is to try and determine.
Well, this is a case where, I mean, the reason I draw attention to it, not because it's a direct template, but we have a need which needs to be met.
Indeed.
It's not something that is, there's a time constraint on it being provided. It needs to be suitable, not just in terms of its location, but the impact on amenity, the impact on highway safety. All of those issues need to be fed into the question of suitability, and then it needs to be economically viable. In other words, the land needs to be available at a price, and the development needs to be feasible at a price, which means that it can be delivered. So all of those seem to me, but you can tell me I'm wrong, seem to me to be things that in judging what weight one might give to a site being put forward as an alternative site, what weight one would give it in trying to come to a view as to whether or not it was something that was significant in the planning balance.
Well, can I deal with that in two ways? First of all, my lord, it is not either policy which will apply to this situation or policy which is analogous, because of course the question which the authority is dealing with those on land supply is what's the likelihood of housing sites coming forward for particular material? So what's housing supply we have? If an alternative sites exercise is being carried out, then it may well be, as it is here, a very specific form of development.
But we know that the. I mean, if you think about if you don't like paragraph 72, the other way of thinking about it is, what about when I'm doing a sequential analysis for the purpose of a retail development? And again, you've got to think about what are the qualities of the sites that I'm suggesting as the local authority are more sequentially suitable for your retail, for your shop, than the one that you've identified. And again, the question of availability, suitability, viability would not be the be-all and end-all by any means, but they would be key considerations, wouldn't they? Whether or not a site was sequentially preferable.
Yes, and my lord, I mean, issues would be, well, is it serving the needs? Is it capable of serving the catchment?
We know what they were after because because the planning statement has a range of criteria, doesn't it? So if you go to page B93, we've got a set of search criteria which we've got all real were being applied by the applicant to identify appropriate sites.
Yes, and in a
bit like the supermarket operator who says, I must have 5,000 car parking spaces, otherwise I simply can't trade my shop.
we need and in terms of those criteria, which are sort of set out, the paragraph starts at 93, goes over to page 94. Suitable access for public and service vehicles, including HGVs and articulated lorries. We know, and it's a point picked up by Mr. Russell, this is a quarry that's got access off the A418. So presently taking heavy.
Yeah, I'm not suggesting there's anything. I'm just saying in terms of the point you made as to what are we looking for to accommodate development. They'd already crystallised that.
Yeah.
So the qualities that I'm discussing with you are in addition to that.
Yeah.
In order to make a proposed alternative one that is a runner or one that is something to which weight could be attached in the development control process, as opposed to a pipe dream or a something which is simply not remotely feasible.
Yeah. And my lord, in terms of the sort of is it a runner? There's nothing in 4.3 or 4.4, well, what identified sites should allow for. There's nothing there which there is any evidence could not be met, and
but we simply
just
don't know.
well,
but what we do know doesn't throw up any conflict with this.
Indeed, my lord, that's right. What we do know is that it's a site which is outside the natural landscape, and the policy is to seek to avoid development in the natural landscape. It's a site which is close to the existing and the proposed site, about 600 metres away. It's a site which is accessed off the same main road. It's a site which would seem to be close to the same catchment, so Sheringham and Cromer up towards the north and the northeast. It's a site which is a quarry being in the course of being worked out, and the nature of course of that is that, again, you take it that quarrying will be taking place sequentially or in phases across the site. There will be restoration following on. Obviously a permanent facility here would change the restoration. There's nothing that's for the purpose of the court's evaluation, because none of this has gone into by the authority, not scrutinise their analysis. Court's evaluation is nothing that's a showstopper. there, and one might see it on its face. It's a more attractive site than an agricultural site which is within the national landscape. So there's nothing as a showstopper there. In terms of availability, obviously on looking at alternative sites, the developer will put forward that ultimately when putting forward the site they've got an agreement with a control over. So other available sites would not be ones the developers got lined up. To take the retail example, if you ask Tesco what are the available sites, they won't say, well, the only available sites are the ones we've got an agreement over. But there's that scale on question of potential availability from a site that is on the market, to take my water, a site which is actively on the market, one end of the spectrum. Alternatively, a site where the owner is saying, well, I've absolutely no intention of selling this to anybody, I don't hang on to it because whatever is in my interest, or I want to hang on to it. To have a site where you have an owner who is willing to engage in discussion about sale, or whatever arrangements, lease would have you for this particular form of use. And the evidence which we have is before the court is that the owner was prepared, willing to engage in discussions about selling or leasing his site and part of it for those purposes. So to go to the question, is this something which the site which might have actually made a difference to the analysis, then from the extent to which the court can deal with it, then the answer is yes, it might, and to the extent for the planning authority to deal with it, yes, it may well be the authority would take a view that this is the other site. It's not a better site in planning terms, although one may see that as being quite a difficult conclusion. They'd have to look about the availability of the site coming forward. But
as I understand it, your submission is a relatively modest one. You're not saying that on the 24th of May, had the committee known that this potential site was outside the national landscape, the committee would then have said, okay, well, we're just going to reject this planning permission. As I understand it, your submission is that it might well have said, well, knowing that there was at least one potential site outside the national landscape, the committee may well have said, well, they need to come up with more evidence of a site search.
Yeah.
So it's not, you're not saying, as I understand it, with this extra information, they would have come to a different planning decision, as it were, an outright planning decision. As I understand it, you're saying there's a possibility that they would have deferred and required more information. Is that right?
Yeah. My lord, that they wouldn't have made the decision they did to approve if they had been, if the error had not been made, if they'd been aware of the possible potential of this site, then they could have said, well, actually, we don't think that this is said to be a finely balanced decision, but there seem to be alternatives outside the national landscape, an alternative outside the national landscape, so we'll refuse. They could also have said, given we're also being told the site selection process isn't adequate, and we know that there is this potential site, we need more of an explanation. But of course, what, in a sense, this goes to how the court can deal with public law error and the consequence. It's not, of course, for the court to say, well, actually, it would have been a different decision. The question is there a serious error, something that might have led to a different decision? And that, of course, is because the court is not able to enter into the planning merits. It's not for the court to say, well, what the decision would have been. It's not possible for the court to have ascribed certainty to that. There's discussion of, is it in the context of Section 31 and relief in the recent decision of this court in Bradbury, which is referred to in the skeletons, the comments by Lord Justice Lewis in that context. So in a public law challenge, it's a matter of, is there an error? I'll come back to error in a sentence or two. And is it, in that case, then relief will follow unless it's highly likely that the result would have been the same, that there would have been a petition back. Now, in terms of whether there's an error in the context of an error in committee reports, the authorities are very clear, right? It needs to be an error of significance. So that's as far as the.
Do you mean it should be, it's materially a misleading error?
Yes, my lord.
There's the materiality aspect.
Materiality, serious misleading, right different ways of putting the same point.
And that's a question for us as to whether this is the sort of error which, had it not been made, the council was likely. What's the test for would like to come to a different decision?
Well, it's may or might. I mean, if it's highly likely, there's a sense of the relationship between whether an error is material and the Section 31 relief test. There's a bit of if it's highly likely it would have made no difference, then in that situation, relief couldn't be granted. The court was entitled to say that, well, it's not serious or material error. But unless the court could have that.
I'm not sure we've got Mansell in I'm just looking for Mansell in the authorities bundle.
Well, it's not, my lord. We've got extracts in the judgment.
Yeah.
Just paragraph 42 at paragraph 40 of the judgment.
Right, thank you. So, and in particular, this is really what we're focused on here is paragraph 42 of Mansell, subparagraph.
Can I have a page number? I'm struggling with
page A95
95, thank you.
is the.
Yeah.
So the top of that, which is part of paragraph 2, questionable, the fourth, fifth line, questionable whether the officers materially misled the members on a matter bearing upon the decision errors gone uncorrected. Minor or inconsequential errors may be excused. And of course, misleading in that context, of course, has nothing to do with intentional or tender. It's what's the whether there's an error in the report, an omission, and then the paragraph 3.
Well, is it the end of 2? The question is whether the decision would or might have been different.
Yes, it's so would or might. So might is sufficient, and might is usually the position there. And paragraph 3 is emphasising this, and I think we've discussed there's a number of different ways where we're putting it the same way, significantly or seriously misleading in a material way. It's all to the same purpose. And then Lord Justice Lindblom gives a number of examples. Loader, which we do have in the authorities bundle, was a situation where the report had said that the Victorian, is a heritage issues in the case, the reporter said that the Victorian Society, who won the National Amenity Societies, had not commented. What in fact had happened was that the email to the Victorian Society had gone to the wrong address, so they'd never even known of the application. And the court took the view, well, that was misleading, both in terms of saying they hadn't commented. The reason they hadn't commented was that they hadn't been told, rather than they had been told but had nothing to say, and that the planning committee could have inferred from being told that they hadn't commented that the Victorian Society were not significantly concerned about it, and that in that case was sufficient to bring down the decision. It does become a matter of the court evaluating what the significance of the error is, but which is why the expression "might" is important. It's very rarely going to be the case where we look at an error in a public authority's decision and conclude that the discretion undoubtedly would have been exercised in a different way. Those situations arise occasionally, but an exercise of discretion, of course, is in principle going to be very wide. So the court role is to say, well, might this have made a difference? And that is what makes something into a material error in public law terms.
Can I just explore the relationship between that and 32(1)(a)?
That's a moment.
Sorry, 31(2)(a), the relationship between the might have made a difference and 31(2)(a). So your case, I think, is that this was the sort of error in the report that, had it not been made, the planning authority might have made a different decision, in the sense of deferring consideration to at least investigate this possibility.
At the very least, it
Yeah.
can't refuse. Yeah.
Does 31(2)(a) then encompass the possibility that the respondent could show that had it done that and had it explored this possibility, in fact, this would never have worked because the owner, in fact, has no interest in leasing or selling their land, or the access is hopeless, for a variety of reasons, it would never actually have worked. Is that all encompassed within 31(2)(a)?
My lord, it's not not to that extent of work, and explain why. Because that gets, and I guess why the court below doesn't take that approach. Because if we were to get into the questions of what the merits of it are, or what the precise position or confident position is on availability, that involves consideration of factual matters, some of which might not necessarily be known, or particularly involves further investigation taking place, and it involves, on the suitability of the site, questions of planning merits.
Well, I'm trying to exclude merits points. The knockout blows, for example, the owner's simply not willing to deal.
Yeah.
If it turns out, we have no evidence of what communication, if any, has been made with the owner since all this. But if there had been, and the owner had said, look, I'm just not interested anymore, I was back in 2019, but I've lost interest, then that would be highly relevant, wouldn't it, to a 31(2)(a) analysis?
Yes, my lord, if the evidence was imagine this scenario that there's an alternative that's not been properly considered, has been misreported in this sense, but it was known, or it could be established that it definitely would not have come forward, then that would be a basis for considering it's highly likely. So it's highly likely it would have made no difference. Now, that's an exercise which the question indicates we just can't get to, because there isn't that investigation doesn't take place. There isn't that information, but essentially sort of stepping back, the court is not going to want to be, even without section 31, court is not going to want to be quashing decisions when actually it would have made no difference, because if the error hadn't been made, the same thing would have happened. Or on section 31, it's highly likely the same thing would have happened. But the ability of the court to assess that is limited to what is known and what doesn't involve either reliance on material which we don't know about or an evaluative judgment, which is why this court in front of me is focusing on, well, what's the error, rather than stretching to those further matters. On availability, we've gone through the material. There isn't anything which is suggesting that Mr. Batt would have had absolutely no interest, or that he had changed his mind from an indication that this is possible, I'd like to talk about it. We just don't have that material, and that's something which the applicant would have had to explain if the authority needs to look at it. But so the way in which the High Court, in dealing with the suggestion that this error isn't material, doesn't go into that at all, into the question of availability, doesn't go into the question of suitability of the site in terms of planning merits. But the reason which is given by Mrs. Justice Leven is that, well, the committee already knew that the site selection exercise hadn't been done very well, and that there could be something else coming forward outside the national landscape. And so this information about the East Beckham quarry wouldn't have affected the decision, so it wasn't material. And my lords, that's an analysis which we do say is wrong. That there's, looked at the material before, there's a whole difference between being told you can't categorically rule out anything else, highly probable it won't be anything else there, and then finding that actually the applicant on its investigations had an approach about a site which was just that, outside the national landscape, which hasn't been evaluated. And this is all in the context of policy objections to the site. Whilst there is the need that this site being brought forward in the national landscape, it's contrary to the development plan application that's described at numerous points in the report as being finely balanced. For the note, paragraphs 337, 342, 343.
Sorry, can you say those are tiny bits there?
Sorry, my lord. So paragraph 337, which is at B184, B185, 342, B186, 343, B195, paragraph 4.1, B196, paragraph 4.4. So there's that recognition that this is a let's say a finely balanced decision. It's a decision that does cause harm in policy terms and harm in real terms, because the site is within the national landscape. It's a larger site than the previous and the existing and sort of far too small site which there was. So, my lords, in those circumstances, do say that the errors which we identified are material. Deal very briefly, if I may, with the ground 2 point, which is the admission of the evidence. The reason the learned judge didn't admit the evidence or the amendment which spells out. The point is because of her view on the substantive matters that it wasn't a material error, therefore it was going nowhere, so she wasn't prepared to grant the permission for the amendment and the further evidence. See how my learned friend deals with that and respond as far as I need to, but the learned judge was quite entitled within her case management judgment to take the view that they shouldn't refuse on the basis of any delay. This is the point which, anyways, unfortunately arose just before the day before the substantive hearing. That even if the evidence could have been put forward earlier and so on, there's simply no way that this issue could have been dealt with at the substantive hearing. There was a need to come back to it, and the learned judge was quite right to say that she wasn't criticising or more particularly refusing the application on the basis of any question of delay as to how this has come about. So the procedural issues in this case are ones which do turn on the position on the substantive issue.
Do you have any submissions to make about the fact that, in fact, the evidence is essentially all ex post facto? Something it seemed that the judge dealt with. But it is a factor, isn't it?
Yes, my lord. Which is why I focused on what is the acknowledged error. That the authority thought that the sites which were being talked about were all inside the national landscape, and they weren't, because everything that then follows that is material which the authority didn't evaluate in making its decision. Didn't evaluate the question of whether the landowner had engaged or availability. It didn't evaluate the planning merits points which Mr. Jager raises in his witness statement. So none of that's evaluated. There is, and we draw attention to this decision of this court in Carlton Conway, there is a risk when a public authority puts evidence in front of the court to say, well, yes, if we had made this mistake, we would have actually still come up with the same decision for these other reasons. That is not only a conclusion matter which is simply no one's evaluated, but the risk of it being influenced by wanting to defend the decision which has been reached. And my lord's right that the learned judge doesn't deal with that. The reason perhaps is that because the way she addresses the very narrow basis on which she says that the error is not material, because what she seeks to say is that the committee were told there might be something else if you had a better look, and that's the reason why the error wasn't material. So the learned judge was quite right not to try and go down the route of saying, well, actually, if you looked at the evidence, this wasn't available, or in planning terms, it wouldn't have been a better site, or any of those matters. So she seeks to anchor her conclusion in the report, and that's a conclusion which is wrong. She reaches there that the error was material. It might have made a difference to how the committee dealt with it. That's as far as the court can go, and that's as far as I need to go on that point. Can I just say, that's fine. My lords, unless there's anything else I can add at this stage, those are all my submissions.
No, thank you very much.
Right. Thank you.
me while I just get my papers in. order. If I can start, my lords, by picking up a couple of points that have come across in recent exchanges, and I'll deal with the note upon which my learned friend ended. The advice, he says, the officer gave the council was that there might be better evidence if you had a better look. The county planning authority is assessing an application for planning permission. It doesn't go off collecting evidence. The best it could do is defer and say to the applicant again, and I stress again, because Mr. Gea has been very clear how hard he tried to get an updated assessment. That was the best they could do. Go back to the applicant and say, we would like more information. The applicant would be entitled to say, judge the application on what I've given you, and we're back where we were.
Factor in there may be sites that are outside the national landscape area as a factor against the grant of planning permission and strike the balance you see fit.
Indeed, as they did in the decision which is before the court. Another small point just to pick up for completeness. I'm instructed that the lease of the application site was subject to the grant of planning permission. But I will say a bit about the moment at which the applicant, a public authority with statutory duties, chose this site. It was in December 2020, and we'll go to the documents. And at that point, invested time and money in drawing up a scheme. And that affected its resistance to the idea of looking at further sites. And that resistance was part of Mr. Gea's very detailed report to the committee, and therefore fully taken into account. And a third, I hope, fairly short point. It was my Lord Justice Zacaroli who said, we have no information about the owner. He might have said he wasn't interested. Ironically, perhaps, the whole basis of the appellant's case is founded upon an approach by the owner, a Mr. Batt, the same Mr. Batt who's in the emails that are found at B63 to 78. That Mr. Batt approached the claimant, as it then was, just about, I think it was the day before the opening of the High Court case, and led to the application to adduce new evidence, which was supported by Mr. Reed's third witness statement, which you have at the 190 something. It starts at, sorry, no, I've got the wrong. Just a moment. It's quite early on, forgive me.
35.
35, I'm grateful. And at paragraphs 9 and 10 of Mr. Reed's statement, and he says this new information from Mr. Batt came as a great surprise to us, as the only reference to the quarry site in the application documents is in the supporting planning statement, where it is said that in summer/autumn 2019, instruction given to NPS to commence search for an alternative site and inquiries made by NPS with 15 local land agents for property in the area. From that search, 3 options were explored. 1, the quarry adjacent to the current site. That is the site on the opposite side of the road, the site we're dealing with. However, I'm so sorry. The quarry adjacent to the current site. However, the landowner did not engage, and that is the advice with which we're dealing. It's apparent, says Mr. Reed, that the quarry site was considered alongside the application site, which is right. There were 3 sites that came up. The quarry, the landowner didn't engage. the current site, which is on the opposite side of the application site, which the applicant looked to extend and decided it wasn't feasible, and then the application site. Just 3 were thrown up in that 2019 process, the first of which, the quarry, the landowner did not engage. I'm back to the witness statement. It's apparent that the quarry site was considered alongside the application site and expanding the existing site, following which the decision to progress the application site was taken. This new evidence is therefore highly material to this case. And he goes on, having discussed this with Mr. Batt, he was surprised to have been said to have not engaged. And then we are referred to the exhibits which show these emails. If Mr. Batt had engaged with NPS, and he had also telephoned them a number of times. However, when NPS did not respond to his calls and NPS and the council did not respond to his email in 2021, he assumed they had changed their mind. Mr. Batt is happy to provide a statutory declaration detailing this information. So in this case, we've got contact from Mr. Batt, and it's my submission the court is entitled to take notice that he says nothing about the availability of the site in 2024, which is the key date when the decision was made, or even its availability now. All he does is correct the record and criticise the advice the landowner didn't engage.
So where does that go to? Because neither side has sought to get any evidence from Mr. Batt.
Well, we're dealing with a judicial review, so we're looking primarily at the information before the council. And then once this error in the interpretation of information received by the council is identified, we have felt it necessary, pursuant to the duty of candour, to explain the position and the implications of the error for the decision. But the focus is all on that decision and the question whether it was materially misleading, whether the advice given was materially misleading.
So we can't make any.
So
sorry.
it would not be for the county to do more than explain its position. It would be for the appellant to say, and he would have liked to press. He would like to deliver the site. He would have liked to deliver the site. The fact that they didn't is worthy of note. That's as far as my submission goes. It's not a slam dunk on the legal point.
And I'm sorry to speak over you.
No, not
forgive me. I noticed that he does say in paragraph 6 that Mr. Batt said that the quarry site was available. So as I read that statement, he is actually saying the site's available for what it's worth. And I think on a natural reading of that, it must mean it is available, or was available in 2024.
Well, I regret to say my reading of that was that it was available in 2019.
Well, it seems an odd thing to be saying, because you can't, unless Mr. Batt has some archaeological interest in ancient events, the natural reading I would suggest of this evidence is that he's saying, look, this site's available. I don't understand why the council has made this decision. That's why he's come forward.
Well, I would say that the position as I've interpreted it aligns completely with the way in which this is argued. This is argued as being on a very, very narrow point, simply that the claim that the landowner did not engage was misleading, was incorrect. And therefore the focus of this evidence is on the 2019 position, in relation to which it is said the landowner did engage. And that is as far as my learned friend's case goes. He has not, and properly I would say, because he doesn't have the evidence, he has not sought to argue that there is any evidence that the site was, the quarry site was available in 2024. his case is the one that has an archaeologist at its heart, that is looking into the history books. And that was a point I was going to emphasize as I develop my submissions, that we are looking at evidence of an exchange of emails some 5 years before the decision was taken. And we're considering how misleading, if misleading at all, the statement that the landowner didn't engage was. So those were the sort of 3 points I wanted to draw out at the start, and I'm going to, slightly out of order with the points I was intending to make, elaborate just a little on the failure to engage point. If it is right, or at least not materially misleading, that the landowner failed to engage, the site was not a material consideration, and the consent was lawfully granted. And the importance of the lack of availability of the site at the time of the decision is underlined by Mr. Geyer's second witness statement, paragraph 7, B41. He says, at the time of writing the OR in 2024, I understood that the quarry was not available, given that the submitted planning statement stated the landowner did not engage. And as such, I didn't consider the possibility of the proposed HWRC being situated at what I understood to be Beeston Regis Quarry. I did not mention it in the OR as an alternative site. I also did not seek clarity from the applicant as to what quarry they were referring to, given that it would not impact the determination of the application, as it was stated the land was not available, and the sites that were understood to be available were listed in 3.12 of the OR and duly considered. The key fact in this case is that the quarry was not available at the time of the decision, and Mr. Geyer, the case officer, correctly understood that to be the case. So a little context to the way in which that site came before the council as applicant, and how that affects this decision. We know that any engagement, such as it was, ended in 2019 after 6 attempts by NPS, the agent of the applicant authority, the Waste Disposal Authority, to engage with NPS, being the agent of the authority, was engaged to do an updated assessment of sites available. As your lordships have heard, 15 land agents were asked to give feedback, and there was no actual report that followed, but 3 sites were thrown up by it. But NPS did not have an ongoing brief, is not part of the applicant Waste Disposal Authority. It will have provided its advice to the authority, which would then have found its way into the updated planning statement of January 2024, some 5 years later. 4 years later, to be fair, because it was the end of 2019. And we know that by then, the interest was historic and had been superseded by an important subsequent event, namely the decisions taken by the council as waste disposal authority to choose the application site made in December 2020. So if I can take your lordships to B94, we see this is the planning statement updated. We see at 4.5, to which you were taken by the learned friend, the further assessment of the suitability of alternative sites and discussions with landowners led to a preferred site being identified. At some point, an applicant for planning permission has to decide which site to go with. Your lordships will see that the date that happened was December 2020. The preferred site is shown in figure 4, which is the figure at the top of the next page. Then there's an agreement to enter a lease by the cabinet and a declaration that subject to the replacement site being operational, the existing site was surplus to requirements. At 6, we have the timeline introduced. Your lordship see how long this goes back: 2015, 2017 spring initial search taken by the agent, Norfolk Property Services, known as NPS. The findings from that search are at B52. I don't need to take the court to them, but none of those 2 potential sites were considered suitable. And in due course, February 2019, the council further considered its existing site and potential for extension before, in the summer, asking NPS to commence a search for an alternative site. And there is the source of the advice to the applicant authority conveyed in this summary table to the planning authority. I draw your lordship's attention to item 9. In December 2020, the selection criteria assessment was completed, highlighting the superb location for the new site to be constructed, describing that location. There were additional benefits. I'm pointing to halfway down that entry, and the improvements that it would bring, particularly to access to the Appellant's activity centre. And over on page B97, final paragraph under this row 9, starting, the assessment recognises that it would be preferable to have further depth to the land search investigations to support the waste local development framework or strategy. However, consideration has been given to the benefits of the proposed location, and additionally that no other suitable and available land was identified between the land search commencement in the spring to the point of submission of the planning application in March 2023. So that is the context, and if I can take your lordships to as well the so sorry, the OR at the officer's report at B181, paragraph 3.26.
Can I have the page again, please?
B181,
Thank you.
paragraph 3.26 of the officer's report. This refers to the addendum to the planning application, which your lordships have starting B123, but I don't need to go there, where it's highlighted that the development is required to be located in this location, but the applicant has only given a limited consideration of sites that have come forward due to the timings of becoming aware of the other sites. The application, and that is the Stonehill Way site particularly referred to. It came forward during the currency of the application. The application the applicant has provided limited justification as to why the land immediately west of the existing site is inappropriate, along with land that has come forward during the planning process in Stonehill Way, but has clearly set out the selection criteria that was used, and this is the point I wish to emphasise, the cost implication to the public purse if the site chosen to progress with in December 2020 changed during the design process in both consultant fees and land acquisition fees in tackling paragraph 13B of the NPPF. Therefore, on balance, and so forth. That drives home that the applicant had, and it's not the applicant in, as it were, under scrutiny here, it's the decision of the CPA, the County Planning Authority, which is reliant on information provided by the applicant. That makes it clear that the applicant had decided to go with this application, so to speak, and to have it assessed on its merits.
What happens if an applicant gives misleading information in the application?
If that is
Then infects the
yes.
decision.
Then, albeit it may not be the fault of the CPA, if it is significantly misleading,
Then it's significant.
that's the end of the story.
Yeah.
Yes. Just a final word on failure to engage, whether or not it was right. Learned friend found himself addressing the court on the meaning of the word "to engage." At its worst, at its highest, the appellant's case is this: that the landowner showed signs of being interested, but then failed to engage, or the landowner failed to engage after showing some interest.
Well, if one places what you just showed us in the chronology alongside the emails, what appears to have happened is that there was some inquiries made of the landowner, some exchanges of emails in an attempt to set up a meeting in 2019. The trail goes cold because there is no response and meeting is not arranged, and in the meantime the applicant identifies the site that is its preferred option in December 2020. And so when Mr. Batt gets back in touch in 2021, the ship sailed.
Well, and importantly on that, Mr. Batt makes it clear that he thought that matters had moved on and did not press his case. He let it be.
Mr. Batt got back in touch with NPS.
He wrote to NPS, he copied Nicola Young,
That's right, yes.
who has since left the authority, I regret to say, so obtaining evidence.
Yeah.
There,
Mr. Russell was still, well, it was prior to Mr. Russell's retirement, I think, which is in 2023.
But you made a point.
Miss Young, Mr. Russell's retirement. Yes, correct.
But you made a point earlier about NPS not having a continuing brief,
Yes.
as it were. When do you say their brief ended?
I don't know.
Right. Okay.
But the email in any case went to the council itself.
Forgive me.
Sorry, the email also went to the council and not
It did.
just to NPS.
It did.
Do you have any submission about the statement on page B97, which is part of the table?
Yes.
In the first block, however, consideration has been given to the benefits of the proposed location, and additionally, that no other suitable and available land was identified between the land search commencement in the spring of 2017 and the point of submission of the planning application in 2023. So that's covering the whole period right up to March 23.
Yes. So on its face, that illustrates that the applicant authority, in preparing this planning statement, did not have, that first of all, they had not followed up on the email to Nicola Young. And I think there have been requests for information. We're not aware of any follow-up by the applicant authority following the receipt of that email by Nicola Young. So there is just another gap in the record at that point. But we are left with whether it was materially misleading to say that the landowner failed to engage when as part of the investigation in the line on page B96. And I do say, I do submit that the onus is, in a case of this kind, on the appellant to satisfy the court that there was an available and suitable alternative site in May 2024 when the decision was taken. And the evidence is not capable of satisfying the court of that important matter.
Earlier on, Mr. Harwood was saying threshold in relation to that, as I noted him, the threshold for there being an alternative site was low. You've just said that the onus is on him to show that there's an available and suitable site. Well, that's all. Both of you are all being very adjectival about that. I'm just wondering what you mean when you're saying available, what you mean when you're saying suitable. Because there's a very wide spectrum of what might, as I put to Mr. Harwood, might be certainly in the compass of available and probably in the compass of suitable as well.
And in the first instance, it's a question of judgment for the authority, not for the court, whether a proposed site is suitable and available. And you've heard, I've taken your lordships to Mr. Jay's second witness statement, which addresses that. He also considers suitability to some degree, which I didn't mention.
When you say the authority, it's for the judgment of the authority.
Of the planning authority.
So
my client.
Right. They didn't know about this, did they? They weren't told about this. About the non-engagement of the landowner. It was in a document that was available to them, but it's not a point taken in the report, is it? The only point taken in the report is the other area which Mr. Harwood, for understandable reasons, focused on.
Yes. So whether an individual member knew and had taken the trouble to read the planning statement, it would have been available to them. Whether they'd actually read it is not really pertinent, if I may suggest. Instead, the thrust of the recommendation and the basis, the overall basis of the recommendation, is the area of focus, and whether that was misleading. What we're doing here is looking at whether the recommendation was itself misleading because it incorrectly drew on that fact, and therefore it wasn't an alternative site. As Mr. Jaya says, he didn't list it as an alternative site because it wasn't available. And the question is its availability, not whether or not the landowner engaged. The question is, was it available in 2024? We're looking at reasons for reasons here by looking at the planning statement, if I can put it that way.
Well, as I understood the argument against you, it's not about whether there was actually another available site, or at least this was one way it was put. It was that the planning committee might have come to the decision that it would not give permission without requiring the applicant to do a further and better property search. So it wasn't, as I understood the argument, it wasn't really about whether the decision was vitiated because there was an available site. It was that it was vitiated because the committee might well have said, we need an updated, better search. And the reason for that is that the committee would have known that when a search was done before, one site, which was described as a potential site, I think, was outside the area.
So at this point, the analysis starts to look like a Thameside argument, that it was necessary for the authority to have undertaken further inquiries.
Not for the authority to have done that, for the authority to have said to the applicant, we're not going to give you permission today. It's up to you. You can go away and provide us with further information in the nature of an updated search. Not, as I understood the argument, that the planning authority itself should go and undertake that search.
So the case officer had the discretion to, or exercise the judgment in whether or not he would recommend approval or refusal. To achieve what your lordship suggests, it would have been necessary for the recommendation in the report to have been, in the light of this poor assessment and the possibility of a site in outside the landscape, I would recommend the council defer until one is provided. There's some difficulties with that. First of all, Mr. Gere made his recommendation on the explicit understanding that there may be sites that were suitable and outside the national landscape. And yet he exercised his planning judgment in favour of grant. And that planning judgment was a reasonable planning judgment, the contrary is not said, taking into account the poor quality of the assessment and the prospect of there being suitable and available sites outside the national landscape. That is why the error, insofar as it has been demonstrated to be the case, that is why the error was not material. And the key error, which has been admitted, was that the quarry that was identified in 2019 was in fact outside the national landscape. Mr. Gere had fully anticipated that there may be sites outside the national landscape. But back to your lordship's point as to what the appellant says should have happened, it comes very close to saying to a disagreement with that judgment on its merits, that the officer who knew that there was potential for sites to be suitable and available outside the landscape might alter his recommendation because in 2019 there was a potentially suitable and available site, that is 5 years before, outside the national landscape.
Well, it could be said that his judgment was vitiated by the error he made about the land, not the potential, one of the three potential sites, not in fact being within the national landscape, but you would say, but his judgment was based on another factor which overrode that, which was that wherever it wasn't available.
Indeed, so 2 points. The fact, even if it had been available, his position was there may be sites outside the national landscape. Therefore, and this is very important in a planning judgment, this site is a departure from the development plan. You have a presumption in favour of refusal because it does not accord with the development plan. But, and he takes into account a host of issues, including the low level of harm to the landscape, which is the issue here. And yet there's low level of harm to the landscape. He takes into account all the material considerations that justify a judgment in favour of the grant of permission. And if I can move, there are a few contextual facts, and so often in cases like this, and it is a case that very much, I hope your lordships will agree, turns on its facts. The law is largely agreed. The contextual facts, which are not contested. First, what's proposed is not major development in the national landscape. And in such cases, the requirement of exceptional circumstances, a different policy environment arises. That was actually ground 2 in the court below and failed. Not major development. One of the key issues, as stated in the OR, correctly stated, I submit, this is at I think it's 3 point, I'm not sure, sorry, the reference is whether suitable sites are available outside the national landscape. Expressed in the present and correctly so expressed in my submission. One of the key issues are set out at B168. This was another contextual fact that goes to the judgment actually made. This was a replacement facility for the existing site, which is in the national landscape as well, and its development would lead to the restoration of that site. The learned judge records that at paragraph 6. I don't need to go there, but that's at A86. And the impact on the national landscape was judged by this officer to be minor, and it is worth looking at that, B185, which is paragraph 3.42 of the officer's report. If one goes, it's a fairly lengthy paragraph, but if one starts right at the bottom of page B185, however, the proposal does still have an adverse impact on the landscape and scenic beauty of the national landscape, albeit minor. The addendum planning statement, another matter that gives us some context to the decision, includes a section on alternative sites, and that is B128, identified by the learned judge at paragraph 20, which quotes from it, but B128 has it. The final paragraph on B128 is quoted by the judge at paragraph 20. I don't read it out, but I do ask that to be taken into account. An assessment by the applicant of a site, said by Hilltop in the court below at the outset to have been outside the national landscape, found to be inside the national landscape, but that is a matter of history now. So those are the matters of context that I just wanted to touch on before moving into areas of law. It's trite to say that matters of planning judgment are for the authority, and questions of the extent of investigation required to reach a decision, those are matters of judgment for the authority, as Thameside makes very, very clear. As is, generally speaking, the question whether it's necessary to look at alternative sites, matters of judgment for the authority, Derbyshire Dales.
Well, this is a case, isn't it, as I said earlier, where alternative sites are material, and they're material by the policy context in which the development arises.
Indeed, and through that policy context, section 70, it was a material consideration. It is worth looking at how the policy context works, so that can be seen. Its core strategy, CS6, in the bundle at B134, feels like I've got that wrong.
I think that's wrong.
And yeah, thank you, that was a dyslexic moment.
Is it 311?
314, my lord,
314.
is CS6, that's the Norfolk Minerals and Waste Local Development Framework 2011. So that is a policy for general waste management, provides the general considerations for waste management applications, and does identify existing mineral workings as a potential. But interestingly, this is under the letters. Interestingly, says will be restricted to a temporary permission lasting till the cessation date. I don't take any particular point on that, but the appellant.
I thought I'd read that the quarry had a condition requiring it to cease in 2031. Is that right?
That is as I understood it. I couldn't take your lordship to the reference, and I couldn't swear it. That's that one. And then over the page, the text introduces policy DM6. The policy at the top of the page, 315, is not relevant, but household waste recycling centres are introduced there, and 7.26 is of interest relating to the constraints on the existing site at Sheringham, just of some relevance, and 730. Although most potential HWRC improvements or new HWRC locations will be able to meet the tests of CS5 and 6, there may be cases where there is a demand for an HWRC in a certain area, but no suitable sites. That is to say, sites which meet CS5 and 6. In these cases, DM6 will allow an appropriate proposal. So when we look at the first paragraph of DM6, which begins where there is a demand for a new or improved HWRC in a specific area of Norfolk, as there is here, but a suitable site in line with CS5 and 6 cannot be found, they will be acceptable within purpose designed or suitably adapted facilities on other sites, including greenfield sites. So DM6 makes provision for a development of a site such as this, but only if a suitable site within policies CS5 and CS6 cannot be found. That is why it was important to establish, for the purposes of compliance with the development plan, whether or not an alternative site could be found. And the consequence of not being able to say that a suitable site cannot be found, but only being able to say a suitable site has not been found, the development was a departure from the development plan. Section 38.6 requires decisions to be taken in accordance with the development plan, unless material considerations indicate otherwise, hence the importance of Mr. Geyer's careful planning balance in the overall result. And just a point on the base, a further point on this, because it has been said by those representing the appellant that there was a common law duty to consider alternatives, which led to some elaboration of the proper basis for finding a duty to consider alternatives in this case, and the written explanation of the basis on which the county planning authority accepted the duty, which is found at B270. I offer that just for your lordship's note, and it is dealt with in the judgment below at 60 to 61 and 65. There are 4 cases in the bundle that deal with the duty to consider alternatives, or although not all of them are properly analysed in that way. That is the Derbyshire Dales case, which is at tab 3 of the bundle, the authorities bundle, the Forge Field case at tab 9, the Balajigari case at tab 5, and the Langley Park Girls' School case at tab 10. I've dealt with all of these in my skeleton argument. I will just say a word about each of them very briefly, if that would assist the court. The Derbyshire Dales case, of course, was the one in which an inspector deciding an appeal seeking permission for 4 wind turbines had said, no, I don't need to consider alternatives at all, and which is really the case that sets out the scope, the way in which it's assessed whether a duty applies at all. The Forge Field case is most helpfully analysed. That was a case in which Mr. Justice Lindblom, as he then was, quashed a planning permission for affordable housing on a site that was not only in the Greenbelt, but also in the setting of a number of heritage assets, and in relation to which there was a letter from lawyers I'll go back a step. There were 2 applications before the authority, and a letter from lawyers for one of those saying, what about, to deal with the difficulties of this site, what about a joint enterprise between the 2 of us on a different site? So there was a proposal before the council at the time it made its decision, which it ignored. So it was a failure to consider a material consideration. Nothing historic, no duty to go back to the applicant and say, I need more information. Balajigari is a more up-to-date consideration of the Thameside duty. The facts are fairly complex. It's an immigration case, but the long and the short of it is that the court, Lord Justice Underhill's leading judgment, decided that the procedure followed by the Secretary of State in that case was unfair, but he held against imposing on the Secretary of State a Thameside judgment, a Thameside duty of further investigation. And finally, the Langley Park Girls' School case, which I deal with in my skeleton, like all of these, is a 2009 decision of the Court of Appeal with Lord Justice Sullivan giving the judgment, and is best analysed not as an alternatives case, but as a case falling squarely within the duty to consider all material considerations. There was a failure to take account of an alternative option on the same site. Again, something present at the time of the decision and very clearly material in its implications for the decision and the way the decision was taken. If if I can help your lordships with those cases further, I was just aware they weren't even touched on by my learned friend, so I thought I'd deal with them in that, I hope not too loose way. I'm obliged. I'm going to return to the facts, and there was a further issue I'm keen to touch on, and that is also within Mr. Geyer's second witness statement, where he says something about the steps he took to obtain more up-to-date information, and that's at B42. Paragraph 8. So sorry, it starts at the bottom of B41. I do apologise. So I've already taken the court to paragraph 7, but it goes on. Notwithstanding this, I sent 10 emails to the applicant between 23 and January 24, asking the applicant to provide an up-to-date site selection assessment that considered all sites available at the time the application was lodged. Just for clarity's sake, the exhibit he refers to isn't in the bundle. It can be provided if needed, but we didn't think it was needed. To address the requirements of the local development framework, CS6, and then he quotes from it. But this was not forthcoming. I also made it clear to the applicant that if I was made aware of any other available sites that meet policy requirements, I would expect the applicant to respond to these, setting out whether they would be suitable. As such, I made it explicit in the OR at paragraph 4.3 that the CPA would have expected a more recent assessment to have been submitted in order to fully comply with policy so that we can be satisfied no land was available on sites outside of the national landscape and or on land meeting policy CS6, which demonstrates that the recommendation and decision was made based with the knowledge that there may be a more suitable site available on land outside the national landscape. This was also made clear in my first witness statement at paragraphs 31, 32 and 35. And I'll give your lordships the reference for those, albeit I don't need to read them out. 32 is at B14, as is 33, and 35 is at, well, they're all at B14.
I'll just ask you a question about his evidence in paragraph 7, just so I've really understood
Of the
it.
second witness statement?
Yes,
Yes,
sorry,
of course.
B41,
Yes.
where he's dealing with the, he says, I did not mention it. At the time he thought it was a Beeston Regis quarry. I didn't mention it. I also did not seek clarity from the applicant as to what quarry they were referring to, given it would not impact the termination of the application, as it was stated that the land was not available. Is that a reference back to the bit that said that the owner didn't engage?
That is how Mr. Geyer interpreted that advice, yes.
So when he says it was stated that the land was not available, that's his reading of the application.
Indeed.
I see.
And it's the only context in which the landowner the statement the landowner did not engage is relevant for the planning decision.
Because he thought it was Beeston Regis quarry that was being referred to, not in fact East Beckham quarry.
But in either case, it wasn't available, not a material consideration, didn't alter his recommendation.
And that goes back, sorry to be
Not at all.
particularly specific about that, but that goes back to the entry in the table at page B96.
Yes. Finely balanced. Few submissions on this, and I'm unlikely to finish before the luncheon adjournment, if that's okay with your lordships. If submissions would be helpful on the applications and on section 31(2)(a), which I think I ought to address. So I'll finish with this point about finely balanced and the approach taken in the officer's report. So the officer's report, we know, starts at B 187. And I'll touch on a number of paragraphs within it. So the material planning harms identified at 3.27, the departure from the development plan, despite some compliance with policies in relation to the principle of development, top of B182. 3.31, minor adverse residual landscape effects in the immediate context, moderate for the site itself, and therefore some conflict with landscape policies acknowledged. However, 337, weight should be given to the benefits of providing essential infrastructure, which could bring environmental and landscape benefits compared to the existing. And I don't know if your lordships have had a chance to look at the existing. There's a photograph of it at B294 to 295. With the view from the main road at 296, showing what is a shared access for the waste site, which is on the left in the clump of trees in B296, and Hilltop, which is somewhere off at perhaps 2 o'clock in the afternoon.
So just what is the purpose of showing us these references? You started by saying finely balanced. What's the submission you're making about all this?
That one of the tasks for the officer properly undertaken was to compare the proposed with existing, which had an impact.
But
causing problems.
Where does that go to in terms of the legal argument that we're faced with?
It doesn't.
Right.
It's context.
Right. Okay.
And forgive me if it's unnecessary, but it does. The purpose of it, for my purposes, is where there is no challenge, is to the quality of that judgment, and I'm setting out, I hope helpfully, the reasons why that may be so.
Yeah, but we have all read the report in some detail, and I think however, it doesn't gainsay the point that it was a finely balanced decision, because that is said many times throughout the report.
That's fair, my lord, and I'm going to jump to the point about finely balanced. If I can take you to 4.1 of the report. Page B195. And my submission is simply this. Yes, Mr. Gea repeated that it was a finely balanced decision, but this was because it was both a departure from the development plan and it was located in the national landscape, not because the planning harms were anything more than limited. And if I can go on to 4.2, where my learned friend emphasised the first line or the first part of the sentence, saying some weight should be given in the planning balance to the location of a facility between Cromer, Holt and Sheringham having to be situated within the national landscape in order to be suitably located. We read to the end of the sentence, the officer continues, given the sites available at the time when the applicant was considering the requirements of the scheme. So we're back to availability. The lack of availability of a site found outside the national landscape informs that judgment. And finally on this, the law does not go, and I think this is common ground, so far as requiring the authority to locate its site outside the national landscape if possible. Ultimately, it's therefore for the authority to judge whether it had sufficient information about alternatives to the site and where the balance lay. And the basis of that judgment was repeatedly stated by Mr. Gea that that he could not rule out there being sites outside the national landscape. Would that be a good note?
Yes, it
break
would.
for lunch.
It would indeed. So 2 o'clock, thank you.
Court rise available.
So let's get out as quickly as we can and make another word. I'm going to leave my laptop.
Plugging this. Yeah.
Moving on.